Morning, folks. Please be seated.
Oh, he's leaving. To ask him if he wants, what he wants to do.
Okay, let's wait till we find the attorney for the earlier case.
For case number 3. He just went into the ante room.
Oh, okay. So it's a
All right.
reschedule.
Okay,
No, that's okay. He wants a reschedule.
right.
Okay, so we'll reschedule that one, okay?
Schedule, yeah.
Okay, now, the last matter on our calendar is in the matter of the welfare of JDL, a child. And attorneys are well acquainted with our rules, I'm sure. The appellant will have 15 minutes to argue, and the respondent has 15 minutes to argue, and then you'll have 5 minutes of rebuttal. So whenever the appellant is ready, we're ready to hear your argument. I might add, for the benefit of the folks here, you know, we do have cameras here, but I want all cell phones off and I want no recordings made, okay?
Thank you and good morning, Your Honors. My name is Brenda Miller. I represent appellant in this matter. The State of Minnesota County of Waseca is appealing the district court ruling in the matter of the welfare of JDL. JDL was charged with various different counts, 4 counts of attempted first-degree murder, 2 counts of first-degree criminal damage to property, 6 counts of possession of an incendiary or explosive device. At the omnibus hearing, the district court dismissed the 4 attempted first-degree murder charges and the 2 attempted criminal damage to property charges. The state is appealing the dismissal of those 6 counts. The first question before the court, is that pretrial order by the district court appealable? It's the state's position that yes, it is appealable. Under the rules of juvenile delinquency procedure, Rule 2104, subdivision 1E through F, allows for a pretrial appeal if it is based on a legal determination, and that is also supported by a Court of Appeals decision, the matter of the welfare of CPW, and that was a criminal vehicular homicide case. It's also supported by the cases that we cited in our brief, State versus Koenig and State versus Hudson. In the Koenig case, the district court dismissed a count of solicitation of a child for lack of probable cause based on the district court's determination of the definition of a solicit. And based on the facts that were presented, the district court determined that as a matter of law, the defendant did not meet the definition of solicitation. In this case of State versus Hudson, that was a charge of aiding an offender. Again, the district court at the offender, based on the district court's legal interpretation that providing transportation to a defendant does not constitute aiding an offender. Now, in our case, it's very clear from the judge's decision. Not only once, but twice, the judge in his order on pages 6 and page 8 clearly stated he was dismissing the 6 counts due to a matter of law. Specifically, he said the court finds as a matter of law that respondent did not make a substantial step beyond mere preparation toward the commission of first-degree premeditated murder and first-degree damage of property.
But when the evidence is insufficient to support a charge, then the decision is as a matter of law. This doesn't imply that the judge is defining substantial step.
If that was what the judge ruled, but in our case, he then went on to define that the defendant, or excuse me, the juvenile didn't do this, didn't do that, didn't do this.
But he
So-
enumerated things that are clear in case law that would be a substantial step. Did he actually say only these things constitute substantial step?
No.
Is there anything in this case that is equivalent to one of the enumerated substantial steps?
The cases that have already been decided in Minnesota? Is that what your
Is there
question?
any fact in this case that is the equivalent of one of the substantial steps recognized by case law?
By case law, not in Minnesota, but definitely case law in other states when they determine attempts. There are several, I'll jump ahead so I can finish answering your question. specifically State versus Leonard. That's
Well,
from,
I don't want to discuss other cases at this time, other states' cases at this time.
well, there's also the Federal District Court case of U.S. versus Pritchard from the 10th Circuit as well.
But what about Duffy, one of our cases? And Duffy appears to be fairly on point with this because the dismissal was based on articulated elements of the court as far as the sale or conspiracy charge, and a dismissal based on that, we determined that it was based on facts, and an appeal was not permitted.
There was a case, though, specifically, I would argue that Hudson and Koenig, though, the Court of Appeals did allow those appeals, and those were on pretrial dismissal of charges. And again, those cases said that based on the facts that were presented, the defendant's actions did not constitute whatever the legal definition was in those cases. And in those cases, again, it was solicitation or it was aiding an offender. So I do believe there is the precedent already established by this appellate body that appeals of pretrial dismissal of charges are allowable. And,
An unpublished case?
excuse me?
Hudson's an unpublished case?
No, I don't believe so. I believe it is published,
Okay, I see. It was issued in 2014.
as well as Koenig. Then the next issue, whether or not the dismissal of the charges created a critical impact. Again, here's Koenig is a case that supports this finding that, again, in that case, it was a pretrial appeal of a dismissal of charges. The Court of Appeals reversed, and they said, yes, a dismissal of even one count does constitute a critical impact on the prosecution of the defendant in that case. Our case is also a little different in that there has been a certification motion filed. In this case, the juvenile was 17 years of age or older. He was charged with a felony that, if committed by an adult, would result in a presumptive executed prison sentence.
Well, you've argued that as far as it relates to the, whether or not this is going to go forward, but you have not cited any case law that's going to support that if you lose the presumptive certification, that's critical as far as your case, because you still could pursue certification, correct?
We can, but I believe everyone,
Presumption, and that's it.
right, we lose the presumption.
Is there any case law that establishes that losing a presumption in a felony-type situation such as here, that constitutes critical impact?
I am not aware of any case law, Your Honor, but I would strongly urge the court to distinguish the fact that a loss of presumptive cert does create a difficulty in the successful prosecution of the case. The main issue of,
Why can't you prosecute the case in EJJ court or juvenile court?
I'm
How does it
saying
affect
that
prosecution?
you can still prosecute him, but it's going to be more difficult. You're not going to be able to, well, we don't know yet, obviously, what the result of the certification hearing will be.
Well,
But
what you're
we
really
lose-
arguing is the range of sentencing would be limited, not so much the prosecution, but the ultimate outcome in the event of conviction would be limited.
Correct. The main issue, obviously, before the court today is whether or not the district court erred in dismissing the counts, whether or not there was error in the statutory interpretation of, specifically in this case, attempt, Minnesota Statute 609.17. The brief history, we listed this in the brief. I don't want to bore you, but previously the definition of attempt was an act done with intent to commit a crime, intending but failing to accomplish it. Then in 1963, we adopted language from the case of State versus Dumas to state that an attempt is a substantial step toward and more than mere preparation.
Well, let's look and talk about Judge Wolf's order in this matter. The district court outlined specific acts that would constitute a substantial step. Thinking about and reviewing what he's outlined, what evidence was there that these acts took place or were being acted on?
Well, I think that's where we're disagreeing with Judge Wolf, is he was looking for specific acts that hadn't happened yet. He was focusing on what the juvenile had yet to do to accomplish his plans.
He was focusing on the case law, wasn't he?
The case law as it existed in Minnesota, correct. The case law up till now pretty much has been you're either a bad aim, you shoot at someone and miss, you shoot at someone, you don't kill them, you stab them, things like that. It required an actual direct contact with a victim, and that's not, though, the reading of the statute of intent. And no appellate court has ever ruled that you have to cause a direct impact or physical harm on a victim in order to constitute
Well, it has
an
to be
attempt.
more than mere preparation.
Correct.
It has to not be remote in time and place from the intended crime. And it has to be something done with a specific intent to commit the crime, an act done with that specific intent. What fits those three requirements here?
The list that we included in the briefs, Your Honors,
A lot of planning
specifically.
and preparation, no doubt about that.
Correct. A lot of planning, a lot of preparation. 9.5 months. At no time in that 9.5 months did he ever waver from his plan. All he did was modify, correct, enhance his plans. When you look at the fact, we're not asking you to punish somebody for their thoughts. We're asking for imposition of criminality based on actions. And the actions in this case were the 9.5 months planning, the reconnaissance that he did at the school. He was in school for a large portion of that 9.5
Asking
months.
for us to say that you can criminalize intent plus preparation.
Well, preparation and actions. The fact that he manufactured,
Constitutes preparation and intent.
I'm sorry,
Preparation involves conduct, involves
Correct.
actions.
correct. So the question is, at what point does it stop being preparation, and at what point does it become the actions? And in this case, when you,
concern this court has, Ms. Miller, as far as the preparation and planning, you could take a situation in which someone has stockpiled ammunitions in their home, and they have done nothing, and it would allow criminality of having too many weapons, or having things that could be construed as weapons, or having things that could be detonated. And that's criminalizing the fact that you have all of that together. You've got a plan, you've prepared, but you've done nothing to go out and decide you're going to commit what we recognize as a criminal act.
Well, it might be a criminal act on itself if you're not allowed to possess weapons, but
Right.
to criminalize it as an intent to commit murder or an intent to damage property,
I understand your position. I believe the difference in this case is it wasn't just left at home. He manufactured 30 to 40 bombs.
Have a position yet.
I'm sorry?
We don't have a position yet.
He went out in the community and detonated 35 to 40 different bombs.
that might be criminal activity that should be punished. But is it attempted murder?
It is a substantial step toward the act of causing those murders, yes, and substantial step toward, and more than mere preparation of, causing damage. His intent was to use the bombs to either cause damage and/or physical pain or death, physical harm. So the fact that you not just stockpile it, but you put them together, you manufacture the bombs, you take them out in the community, and specifically to 3 schools, one of which was his intended target, the high school. He detonated bombs.
Wasn't intending to kill anybody on that date or to damage any of the property for which he's been charged with intending to damage.
Not on those dates that he detonated them, but it was his intent to hone and to get his bomb making to the level where it would cause as much damage. That was his goal in his journal.
So preparation plus intent equals criminal attempt.
Preparation plus intent plus actions.
Well, how are you dividing preparation from actions?
Preparation, to me, would be more the planning stages. All right, I'm going to write it down, I'm going to think about it, this is what I want to do. It would possibly involve, okay, writing a list. This is the type of
Done everything to make it possible that he could commit a crime.
Correct. But then he went beyond that, and then he actually manufactured the bombs.
Okay, and then he went beyond that and he exploded the bombs.
Correct.
So now we're on this continuum. Once he explodes them, are you indicating that that's his substantial act?
Yes, and his continued actions. The night he was arrested, he had brought all of his Molotov cocktail ingredients and supplies to the storage unit with the intent to manufacture the Molotov cocktail at that time. So once he went beyond his home, once he went beyond the mere preparation, once he actually obtained the supplies, manufactured the bombs, changed his formula for the bombs to get
Any one of those that you're indicating right now would be that substantial act?
Yes.
So anything beyond mental planning, any action plus intent is criminalized.
Anything beyond planning and actually going out and doing an overt act toward the completion. And
So if a person intends to kill somebody, writes in his diary or her diary, I'm going to kill this person on February 24th, goes out and buys a gun, has bullets for the gun, buys a ticket to fly out of the country on that date, has that person committed attempted murder?
buying the ticket and buying the gun, is the gun loaded? I think we need a little bit more fact basis for that. But was the gun loaded? Had he done reconnaissance at the victim's home?
Maybe the gun was loaded on January 15th when he was arrested, but he's put in his diary he's going to kill the person on February 24th.
I'm sorry, what was the first date?
If the gun is loaded when he's arrested, but the diary said he's going to kill the person on next month, has he committed an attempt?
In other states, yes. And the cases we've cited did specifically say that they weren't arrested at the scene, but that they had expressed their intent to kill someone.
Criminalizing dangerousness.
More so criminalizing the fact that they acted and they forwarded their intent on that dangerousness. I mean, anybody can say or think, oh, I wish someone was dead, or I want to kill someone. But when you actually go out and take those overt acts and you take the steps that you need to accomplish that goal, then yes, you're treading the line, and you do face potential sanctions for it.
Preparation ends when you take any action to put a mental plan into effect.
I think it's preparation ends once you take the forward steps to accomplish your goals.
Yeah, but that's where
I'm sorry?
where the rub is right now.
I understand that. And, some of the situations that your honors are posing, aren't as fact-laden as this case. So maybe if you want to just say, yeah, he was going to, I'm sorry, I'm out of time.
You are. That was quick. I think the clock must have been wrong,
Oh, I'm sorry, but I don't want to go over
You can
time.
pick it up on rebuttal.
All right, thank you.
Okay, respondent.
Good morning. May it please the court, counsel. I'm Mark Nivold, representing the respondent, Mr. LaDue. I have with me Steve Bergeson, who's one of the attorneys in the district court for Mr. LaDue. There is no basis for this appeal to begin with. And although I think it would, this case does provide a basis to write an opinion that says the court was correct in finding no substantial step, the threshold issue is appealability. And the case can be resolved simply on that basis. The state's argument seems to be that because the law in Minnesota doesn't permit a finding, a probable cause finding of an attempt, that's a legal issue. No, that's not a legal issue. That just means there aren't any facts here to support a finding of probable cause. The key point, and I think the court asked enough questions
Well, you're
about.
saying no legal ruling, but, there is a determination by Judge Wolf and a conclusion that because the individual in this case did not commit a particular act, that he did not go forward with a substantial step. That's a legal conclusion.
Well, in the sense that a law, the court had to look at a law. In other words, the court has to make decisions based on what the law provides. So as case law recognizes Duffy and Estrella, all probable cause determinations revolve around some principle of law. But here, the court didn't have to construe the attempt statute. It didn't have to say, didn't make an erroneous statement about what is an attempt. It just made a straightforward application of the law. And the state didn't even argue that the law wasn't as the judge applied it. They just disagree that that law governs. They want to import foreign law principles of attempt. So yes, the court, and earlier it was stated, the court said as a matter of law, these facts don't constitute an attempt. But as I pointed out in the brief, that's a way, judges and lawyers always say that when the facts are clear and a statute is applied to them, as a matter of law, there's no crime or there's no complaint or no cause of action. That doesn't turn this into a legal question.
Did the state argue to the district court that the district court should apply the Colorado definition of intent, of a substantial step?
In their memorandum, yes, they did. And before I forget it, here's the key point I want to make about that I think is dispositive of whether there's a legal question here. The reason the state gets to appeal a question that's decided based solely on a question of law is that legal question precludes further prosecution. In other words, they're out of luck. They can't, if they go out and get more facts, it doesn't make any difference how many facts they have. The legal ruling basically closes out the chance of a prosecution at all. The court made no ruling here that prevents the state from getting more facts and trying to show that there's probable cause. Suppose they could find facts that say that he had a bomb in the high school. We just found that out, okay? Then they could bring the case. They could try to reinstate the case. There's no legal ruling here that prevents reinstatement of the case by other means if they can get the facts.
With other additional facts?
Yes.
Not on the facts that are presently
That's
being
correct.
considered.
They need additional facts. So, and I think that makes clear that they can't proceed with this prosecution. Transitioning to
What about critical impact?
well, thank you. That's the point I forgot to make. The reason, because there is no legal ruling that precludes the state from trying to reinstate the case by other means, i.e. more facts supportive of probable cause, there's no critical impact. In other words, critical impact means we can't proceed. There is no critical.
Prosecutor argues that if we would affirm the district court, she is not in a position to go forward with her adult certification.
You know,
Presumption of adult
it's
certification.
unclear to me how the fact that they want to be able to proceed on a charge that gets them a presumption for certification, that somehow trumps and makes irrelevant whether they have the facts to prove the case. They're two different questions. They can't say, well, we don't get to proceed against him as an adult, so you have to find probable cause. Well, wait a minute. I just found the facts are insufficient. Now you want me to find the facts are insufficient so you can get your presumption? I mean, those are two different issues, totally
Based on
disconnected.
what's remaining, is it still possible to proceed against this individual as an adult?
On the 6 counts of the small explosive devices found in the home, and yes, the court found probable cause on those. So those are 6 counts. Those are 6 felonies. But from the state's point of view, they're not satisfied with that because those don't carry a presumptive commit to prison. They're felonies, but they're in the shaded area and aren't presumptive. But so there's criminal sanctions that can be brought against Mr. LaDue, felonies. So this isn't a case.
So do you agree then that the criminal impact that's being sought is really the ultimate remedy if he should be found guilty? The degree of remedy? Degree of sentence?
I'm sorry, I'm just not tracking your question, Your Honor.
What I'm asking as far as the claim that critical impact is vested on whether or not he can be certified as an adult and the presumption, my question to you is, do you not agree that it's not so much whether he can be charged as an adult, it's what the sanctions are that would be available?
Yes, that's where the presumption goes, is the sanctions that are available. It's not whether they can proceed against him. So again, it's
Still
just.
can.
Yes, and it's just an invalid argument to say, we need a finding of probable cause, even though you don't have the facts, just so we can get our presumption. Proceeding to the second question, even if the state somehow could proceed with the counts that have been dismissed, I guess what I asked Ms. Miller to do is to say, when did this attempt occur? Normally, when you've committed attempted murder against someone, they have an idea of what's happened. Now, there are examples where you could unknowingly put some poison in a cup and the person doesn't know that, or take a shot at someone from half a mile away and miss, and they weren't aware they'd even been shot. But in both of those cases, there would still be some evidence, in order for a prosecution to go forward, that the person had dropped the poison in the cup, or someone had seen that person take a shot. My point is here, in the typical attempt situation of attempted murder, you've got an idea that someone tried to take your life. Now, when did this
Miller
attempt?
did argue that on the date that the youth was apprehended, that he was assembling the Molotov cocktails in the storage unit.
Well, first of all, that's not even correct. What he told the police he went there to do was he was going to try, for the one pressure cooker he had, he was going to tape some WD-40 cans around the exterior of it. He wasn't going to put the flash powder in it. He wasn't going to put the ball bearings in it, and he didn't have the second pressure cooker. He didn't have the shotgun. He didn't have all the other materials he needed. He wasn't going to construct the Molotov cocktails. He hadn't assembled any of those, and he wasn't going to do those that night. All he was going to do that night was tape some WD-40 cans. Again, he admits that even if he had done that, if the cops hadn't come that night, it would have been 3 weeks, May 20th, 4 weeks by the end of school, June 2nd, before he was going to be ready to do anything. So there's the remoteness here is stunning, and the fact that they bring a prosecution where he's not ready, he doesn't have all the materials, he hasn't assembled any of the explosive devices that he says he's going to use, in which the state doesn't dispute were going to be used in the plan if it went forward. So I guess I've lost track of where I was trying to go.
Possible that during that 30 days that he needs to get ready, or whatever the time is, that he would take a deep breath and say, you know what, this is crazy, I'm not going to do this.
Yes, and I cited cases that deal with that. The young woman who had the blank prescription, and whether her friend might go and use that. This court said it was a factor that there was no substantial step, that she had time to rethink that idea of letting her friend go and use the prescription. So yes, there was plenty of that. And then the other thing is, this is obviously a young man who has a mental illness, and whether it would be a defense or not, he's obviously deeply troubled. When you read the diary, you can see he has some demons. But he also tells the police, they ask him, well, what's your relationship with your family? Well, I like my parents. They're good parents. I like my sister. He's just, got plenty of time to rethink about whether he wants to kill these people he admits that he loves and doesn't really have any reason to kill, except these bizarre thoughts that are going through his head.
It clearly poses a danger to others.
Well, yes, and that can be addressed. But what the state wants to do is take the specter of what could have happened and say, well, because this could have happened, not that he took a substantial step, we want to be able to bring the sanction of attempted first-degree murder against him. In the time I have remaining, I'd like to give another example. The state talks about what he had done. Well, none of it went beyond mere preparation, but the first thing that the court...
It seems to argue that once you stop the mental planning, or maybe even writing it down in your journal, and actually do some contact, that you've gone beyond mere preparation then.
Well, we're not even close to that here. There's only the preparatory acts. There isn't anything going beyond those.
The state seems to separate acts from preparation, that once you've taken a physical act, then you're beyond preparation.
No, I didn't understand that at all. I don't know how.
For them to be saying.
Yes, but if this case were to go to trial, here's the first thing the judge would read the jury in the preliminary instructions, and that's the definition of attempt Crimjig 501. And there's a sentence in there that says, an act by a person who intends to commit a crime is an attempt if the act itself clearly indicates the intent to commit the specific crime, and it tends directly to accomplish the crime. Tends directly to accomplish the crime. That's what came from Dumas. And later, when you get to the instructions, which are rather bare bones, it says you have to have a substantial step. That instruction tends to directly accomplish the crime, would inform the jury's analysis. Obviously, they've heard that. Okay, substantial step. Does this tend to directly accomplish the crime? That's why the court, when it had to go to case law, found nothing but cases where people had been shot at and missed, or almost strangled in an attempted sexual assault. The cases require that the act you have to be essentially in the process of committing the crime. That's something that directly tends to accomplish it. You can't just have all this mounds of explosive devices and paraphernalia and these writings and expect that to be translated into something that directly tends to accomplish the crime. Just because he's got a lot of supplies and he spent 9 months doing this doesn't get to the stage that's critical, something that tends to directly accomplish the crime. The court recognized that. The other thing is, how can it be an attempt where this case basically falls within the falls very closely to the situation or the story or the example given in the advisory comment written in 1964 to 60917. In there, they say if a would-be bank robber went and bought a gun and sat with it in his home, that wouldn't be an attempt. Now, Mr. LaDue has no completed explosive devices. He's got the materials to do it. He hasn't gotten all the materials he needs.
Well, he did complete them at one time because he detonated.
Right, but the state doesn't contend that, I mean, that's not this case. He's not trying to use those at the school. Those were just part of his preparatory acts to see what he could do to ultimately build a bomb. And the bombs that were supposed to be used were totally different. They weren't going to be these crickets, the CO2 cartridges with gunpowder that he's blowing off at the park. They would have been kettles, pressure cookers with ball bearings inside. But the gun in the bank robber example, where the advisory committee says that's not an attempt. Maybe if he goes to the bank with the gun, it is. Now that gun did not have, let's assume it was loaded. There was nothing that person had to do except go to the bank, and that's not an attempt. Here, the bombs weren't built, he didn't have all the materials, and he doesn't even know when he's going to do this. So even if you look at the advisory committee comment, that basically tells you there's no attempt here. So that's all I have unless there's further questions.
What about the urging us to adopt the Colorado definition, which seems to be conduct plus intent?
Well, that would not only be incorrect, Your Honor, it would be unconstitutionally incorrect, because the U.S. Supreme Court said in the Bowie case that a court cannot, just like a legislature under the ex post facto clause, a court under the due process clause cannot give an interpretation to a statute that it simply doesn't bear, that extends the scope of criminal liability unforeseeably and indefensibly. There's nothing here that would indicate that any court in Minnesota would drastically expand the scope of liability, criminal liability, to the extent that Colorado and other states have, which is you basically just need an act corroborative of your dangerousness, your dangerous intent. That's not the law in Minnesota. If you look at the Fornino case that they cite, the New Jersey case, in Fornino, they say it isn't even necessary for a court in New Jersey to give an instruction that mere preparation is not enough, because sometimes mere preparation is enough. Now, how can this court adopt a case like that, or that kind of reasoning, and say that this is Minnesota law?
Okay,
Thank you.
thank you. Rebuttal. Your last best chance.
And I'm going to interrupt you before you start out with your rebuttal. Mr. Neibold asked that we inquire of you, what would you say is the date of the attempt?
The date he loaded the handgun, put it in the bed frame of his bed, so that if any member of his family were to come in his room, find his journal, It was locked, but if they found it, or they found his bomb-making supplies, or the 3 completed bombs he had in his bedroom at the time he was arrested and the search was conducted, he would use that loaded firearm to kill his family. I would like to correct an error made by Respondent. They argued that the state did not disagree and challenge the district court's interpretation of the definition of an attempt, a substantial step more than mere preparation. Obviously, we're contesting that. We filed the appeal. We did not know the district court's interpretation until we got the district court order. And that's when we learned, oh, this is what the district court is requiring. We don't agree with that, we'll appeal. So we have disagreed and we have appealed. As to sanctions, I know that was a question from your honors. We also have to look at what's best interests of public safety, what's in the best interests of Mr. LaDue. At this point, he's 18. So yes, when we're talking about we lose the presumption of cert, we also lose the different abilities and the length of time to monitor him. I think everyone.
We don't look at consequences when we don't have facts to support a criminal charge. I mean,
We believe there are
start
facts.
The horse?
Well, we believe there are enough facts to support
understand
probable
that.
cause. I'm just trying to rebut somewhat the respondent's argument that we're trying to focus on sanctions, not necessarily, he's saying there are sanctions available. Yes, and that is a factor that does apply.
You can still get certification as an adult.
We could, it will be more difficult. It's not a guarantee. I mean, even a presumptive cert is not a guarantee, but at this point, without those more serious charges, it's very debatable whether or not the state will get a certification in this case, which gives us longer time for programming for Mr. LaDue to protect the public. But again,
Are there other ways the public can be protected in this case other than criminal justice system?
the only other alternative would be some form of commitment, and at this point, we don't know whether or not he would meet the level of commitment.
No one's tried that.
Exactly. But again, back to the Koenig case and the other cases, dismissal of one count in a multiple count complaint has been found to meet the critical impact. Preventing dangerousness, that was another argument from respondent, that yes, the state is trying to prevent dangerousness. Yes, that's the whole basis of attempt law, is to prevent the dangerousness of someone by charging them with an attempt when their actions reach that point where it's more than mere preparation. So we can't lose focus of this,
Well, but
that law.
the attempt law is designed to prohibit specific conduct, not a mental process. I mean, we have a, sexual psychopathic commitment law that basically takes care of dangerousness and opens a whole nother kettle of worms. But here, I mean, it seems like you've got good citizen action, good police work, prevented a horrendous crime, and prevented somebody from actually committing these crimes.
And that is somewhat our argument, is that Judge Wolf, by his ruling and the narrowing of the interpretation, is requiring the actual action, the going to the school, exploding the bomb, shooting someone in order to meet the
Wouldn't
attempt.
necessarily have to be that much.
That's the impression that we got from his ruling.
Remote in time, you have to admit it is remote in time. He's not ready to act the next day or that day.
But he had a plan. He did have a specific date, which,
Well, he had one that went by,
correct, he had April 20th, which was the anniversary of Columbine.
ready to act on that date, apparently.
And it was a Sunday and Easter Sunday, so schools were not open.
We know when he scrubbed that date. Does the diary reveal that?
I believe it would. But then also in the diary, or no, in his statement to police, he told police the next date he chose was May 20th. He did have a specific date. And then obviously the May 20th was chosen because he wanted to do it before school was out, which was, I believe, was June 2nd. The remoteness, again, I would go back to the loaded firearm. He had a loaded firearm in his bedroom with the intent to kill his family if they found out his plans. And I'm out of time unless you have more
So
questions.
that fact alone would make him guilty of attempted murder in the first degree?
Involving the family, yes. That was the intent. That was the substantial step. It was more than mere preparation.
So a person with a loaded gun and an intent to kill someone is guilty of attempted murder.
The loaded gun was in the home where the intended victim was, where the defendant was, yes. In that fact situation, I would say yes.
Person with the right to carry a gun, carrying it around all the time, intent to kill, that's attempted murder?
Again, is the victim in the same location? How long had they been forming the intent? So I have to go back to all the facts, but in this case, I would say that the minute he put that loaded firearm in his bed.
But he never threatened his family.
Not directly, no. In the journal, he did.
Okay, thank you both. This case has been very, very well briefed and very, very well argued. It's a very difficult issue for all of us, and you will have your decision within the statutory period of time. Thank you. And we are adjourned.